Okay, Mercedes been on verdict watch for days in Daniel Penny. Actually, days and days and days. Friday, huge surprise. The jury deadlocked. Prosecutors withdrew and dismissed with prejudice the manslaughter charge against Daniel Penny, leaving only criminally negligent homicide, which is the lesser included offense. The judge, over the defense objection, allowed the jury to deliberate on that charge today. Right this morning, Monday morning, the jury convened at 9:45 a.m. I'm fresh off my live coverage of the verdict being read in the courtroom. The verdict coming back on criminally negligent homicide, not guilty.
Unbelievable. Unbelievable, Misty. Because literally, your M&Ms, you're getting our unvarnished reaction. We have not had chance to process, talk about it. This is our unvarnished reaction to it. Misty, you literally just got off the press. I saw that. I'm about to go on in a little bit. It's pretty amazing. I mean, I thought that I did not, number one, a couple of things. One, I didn't think the jury's going to come back this quickly. I thought they were going to take their time going back through the analysis of criminal negligent homicide, which is different than manslaughter. You should have known the risk, as opposed to knowing the risk and disregarding it under manslaughter. I thought for sure that they were going to take some time. Were you shocked?
So, a couple of things. First, I was surprised. If I had been betting, I would have thought this case was going to result in a mistrial. And I say that because clearly, if some people wanted to convict Daniel Penny and some people on that jury wanted to acquit Daniel Penny, it seemed to me that the root disagreement was whether or not his actions were justified. And if they were arguing over whether or not there was justification, which is a full defense, right? It's full self-defense, defense to the case. If that was the root cause of the deadlock, then that exact same argument would apply to criminally negligent homicide. It isn't different. Exactly. And so when prosecutors were able to kind of procedurally manipulate this case, by the way, not even sure if that was appropriate under the rules. Nobody is, because it's a novel issue that would have been an appellate issue had he got convicted, but now it's moot. But then they're putting criminally negligent homicide on the table on Monday. And to me, nothing had really changed except one thing. And that's why I thought it was going to be a mistrial, right? I thought, well, if they didn't agree on justification to begin with, then what's going to change that analysis now? It's the same element for both. But I'll tell you what I think changed. I think those jurors who had listened to weeks of testimony, listened to the district attorney's closing argument, listened to the jury instructions, looked at the verdict sheet and saw, okay, manslaughter, if we don't agree, we can't move on to criminally negligent homicide, said they were deadlocked, left the room, came back in, and the judge said, manslaughter's dismissed. Come back Monday to talk about this other charge. I think they second-guessed the whole case. And it was obviously the people that wanted to convict that came back in and said, now we want to acquit. And what's the one difference? It's that the prosecutors who were doing this procedural manipulation to get the lesser included in front of the jury, I think it backfired. And I think the jurors thought, well, do the prosecutors even believe in this case?
Right.
Do they even believe in this narrative? Because why did that happen? And they're not supposed to look at the media or anything like that. And by the way, they're not privy to the arguments that went on in the courtroom where the defense laid all of those issues with the judge's determination out. But you don't think that they had the full weekend to kind of sleep on this and then come back into the courtroom Monday morning, 9:45 a.m. And by 11 something, the holdouts, the people that wanted to convict him of the higher charge, are now saying not guilty? I really think it was that. That's the only factor that changed.
That's such a great point, Misty, and it makes such perfect sense. I mean, once you undermine what they have been living through, I mean, we're just covering it for an hour or two a week. Within an hour or two a week, these jurors suspended their lives for 6 weeks. And for 6 weeks, they heard about these manslaughter charges over and over and over again, and then were instructed by the judge that they couldn't even consider the lower inclusive charges of criminal negligent homicide until they were deliberating on that very first charge. And one of the things that I'd heard, and by one of the other podcasters, I thought this was very important. It was interesting because you and I talk about when you put your client on the stand. If you have criminal negligent homicide, he may have actually taken the stand, but why would he have taken the stand and when he's facing manslaughter charges? 15 years in prison.
Yeah, well, it changes the whole
The dynamic.
Yeah,
It changes the entire game. And why would, and that would have deprived him of due process. So you're exactly right. This key issue, the judge changing the rules of the game, changing that instruction would have been the basis of a successful appeal had he been convicted. No doubt.
No doubt. Even the judge, when he granted the prosecutor's motion, the quote was, "I'll take a chance on this," because the prosecutor was asked to present some case law to say that that was a proper act instead of calling a mistrial, that allowing the jury, when they're deadlocked on that higher level charge, allowing the prosecutor to dismiss it with prejudice and then moving on to criminally negligent homicide. The whole thing was not really supported by case law or any precedent. So the judge went into that decision saying from the bench, well, I'll take a chance on it and we'll put this in front of the jury on Monday. And the reason from a defense perspective, no matter who the defendant is, that it's problematic, because on one hand, it was great for Daniel Penny, because if this case resolved in a mistrial, manslaughter charges, the higher level charges, could have never been resurrected.
Right,
so
they were dismissed.
Correct. It was dismissed with prejudice. So they never could have been resurrected. So that really changes the terrain of what a retrial would have looked like, because it could have only been criminally negligent homicide. Top penalty is 4 years as opposed to 15 years. I mean, huge difference, right? But that being said, putting that lesser included offense in front of the jury when manslaughter, they could not come to a consensus, and therefore, under any other circumstances, it would have been a mistrial, was basically asking for a compromise verdict, which, just so people understand what that means, a compromise verdict, it happens sometimes when there's a lesser included charge that is part of the case. And it's almost a way for jurors, if they're at odds about which way to go, to compromise on something that's a lesser charge than whatever the higher level charges are. And what it is basically asking the jurors to put aside what they think should happen, put aside what their convictions say, put aside what they believe is the right outcome, and basically just agree. And it's something under the New York rules, and the rules in every other state says you should avoid a compromise verdict at all costs, because that is not justice. But the argument against what the prosecution did was it was pretty much asking the jury, taking away the manslaughter charge, putting this other charge in front of them to consider only on Monday, with sort of like an elbow, according to the defense, from the judge to say, well, now just consider this one. And it was a problem from a defense perspective.
Definitely.
Because it was asking the jury to basically, okay, you're deadlocked, so compromise on this clearly negligent homicide. But it totally backfired. And by the way, that's not on the up and up from the prosecutors either, because prosecutor's job isn't to get somebody or to secure a conviction. It's to pursue justice. So there was some criticism. Whatever way anybody thinks this should have come out, there was some criticism about that procedural move, especially when there's not a precedent for it in the law, right? So we know that was going to be an appellate issue. But that's why I go back to jurors are people.
Right.
They're making a decision on the evidence in the courtroom, but just like we were all surprised on Friday when manslaughter was taken off the table, I'm sure they were quite surprised as well.
Sure.
And then they had a whole weekend to kind of think about, what the heck does this mean? And we don't know the breakdown. I'm hoping that we hear from some of the jurors about, was there one holdout? Was it 6-6? Was it 50-50? Was it, what was it? What was the breakdown?
Because a manslaughter charge. It was obvious, and we just mentioned it before. A manslaughter charge. There were those, may have been one or more, that wanted to convict on manslaughter,
Yes.
which was
At the point where they
astounding.
deadlocked, we're at the point they deadlocked.
where they would not move from it, and the judge did the Allen charge, which we know, and we talked about it on air, how problematic the Allen charge is. It is in it of itself doing that type of charge. That's why the defense jumped up, started saying to the judge, there should be a mistrial. You are bullying the jury in trying to come to a decision. They're telling you they can't come to a decision. That Allen charge is bullying. It shouldn't be done. Obviously, it fell on deaf ears. The Allen charge was still done, and yet this is when they came back and said, we just can't reach a verdict on manslaughter, which is why we did all these significant changes. But one thing missing all of this, I do hope that at the crux of this case, the mental health crisis is addressed by the city of New York. We have to do something. You and I are New Yorkers. There's lots of M&Ms that listen to us are New Yorkers. We see this type of encounter, not the extreme that happened on that train car necessarily, but we see these types of encounters with individuals that clearly are in a mental health crisis. New York City, mayor, all those that are involved, all of the politicians that are involved that can do something, have to do something. The fact that Daniel Penny has been exonerated doesn't wipe away the real crux of this, which is also coming from the jury. This was a justified act by Daniel Penny because Jordan Neely was in this serious mental health crisis. Something has to be done. It can't fall to the wayside and said, okay, we're done. Justice is served. Jury made the render the decision. No, something has to be done.
Certainly. And that's emphasized, but what came out during the trial that Jordan Neely was actually in a program, a hospitalization. He was being hospitalized. He was in a mental health program. He was getting that help, but he left and there was a bench warrant open for his arrest, but he was never brought back to the facility. And so clearly there is a missing link in the chain of getting people help and services that they need in New York, which was referenced as a part of the case. But, now this case is over from the criminal perspective. Prosecutors can't appeal. It only works one way. The defense can appeal if they're convicted, but prosecutors can't appeal an acquittal. Double jeopardy attaches. Daniel Penny can't be charged with anything else moving forward. It's over. And so now there is a civil case that will proceed that was just recently filed, but because he was acquitted, that means that the civil case will have to proceed. There's no determination of liability or anything. It's just proceeding as its own independent action now with a lesser standard of proof. And so that's going to be the last legal issue associated with this case. But certainly that was a quick turnaround. And I got to say, if I had been placing a bet, I would have thought mistrial just because of what you said. They were deadlocked on manslaughter. So somebody in that room wanted to convict him of manslaughter. What changes by Monday with a lesser charge? Right. So clearly there was a change of heart for some reason. And I'll be interested to hear from the jurors if they do elect to speak.